time for the talk, but in the interest of time, we'll get going. Good evening, everyone. My name is Mary Glazier. I am the director for the Center for Public Scholarship and Social Change and a professor of sociology and chair of the Sociology Anthropology Department, which is a lot to be all at one time, and it's a pleasure to have the opportunity to do this, bringing together all three of those roles. So welcome to everybody. It's a pleasure to have you here. The Justice for All conference started today with two excellent sessions, one on the U.S. Supreme Court, actually 3 sessions. So there was an earlier discussion on ethical and religious and philosophical conceptions of justice to start us off. Really interesting overview of Supreme Court decisions. And if anyone was here this afternoon for the Veterans Court Justice for Veterans presentation, it was extremely moving and I think had a great deal of impact on all of those who saw it. There are copies of the schedule in the back, and there's a full day of activities and presentations tomorrow. In addition, we have out across the street in front of the Student Center a replica of a solitary confinement cell that's being presented to give people an idea of what the experience of solitary confinement is like. And it seemed to me that that's a particularly appropriate thing to consider when we talk about justice and whether there's justice for all. So I encourage you to stop by there if you didn't today and talk with the people who are helping to educate us about what solitary confinement, which occurs for too many people in this country for too long periods of time, what it really is like, and their efforts to advocate on behalf of the elimination of its use. But tonight we're very honored to have David Cole with us. And Professor Cole is from Georgetown University. He's a law professor. He's practiced law. He's argued cases before the Supreme Court. He's done many, many things. Now, we had the pleasure of having dinner tonight, and at dinner I learned that what his real love is writing. And that's obvious from the books that he's written and the way that he writes, the fluidity and passion with which he writes. We have copies of his most recent book, which is Engines of Liberty, the Power of Citizen Action, a Citizen Activist to Make Constitutional Law. And it is that book that's going to be the focus of his talk tonight. And we also have, I think, a few copies of an earlier book that he wrote that I know would be of interest to many students here, No Equal Justice, Race and Class in the American Criminal Justice System. And we continue to wrestle with issues of race and class in our criminal justice system. So even though that book was written a number of years ago, the issues are timely. But it is a great pleasure to introduce Professor Cole to you. I think we're going to be very interested in what he has to say and challenged to think maybe a little bit differently about the way that the Supreme Court makes decisions. So with that, Professor Cole.
Thank you, Mary. So I'm really addressing the question of how do you turn your vision of justice into our constitutional vision of justice? That is, how does constitutional law actually transform? How does it evolve over time? The constitutional law that we recognize today is very different from the constitutional law that was in effect when the Constitution was adopted. And so, for example, if the Constitution today reflected precisely the views and values of those who adopted it at the time, even if you take into account the fact that critical amendments were adopted after the Civil War, the 14th, 15th, and 16th, 13th, 14th, and 15th Amendments. Sex discrimination would not be unconstitutional. Segregation would be lawful. There certainly would not be marriage equality. There would be substantially broader power on the government's part to restrict speech that is critical of the government, and the federal government would be much less able to deal with problems of the economy, with protecting workers and consumers from commercial exploitation. All of that came about through constitutional evolution, and that evolution did not take place through the constitutional amendment process. The Constitution sets forth a certain set of principles. It sets forth a process by which it can be amended, but it's extraordinarily difficult to amend the Constitution. Extraordinarily difficult. So just as an example, I was involved early in my career in litigating 2 cases in the Supreme Court establishing that the First Amendment prohibits the government from making it a crime for people to burn the American flag. Those decisions were unpopular. They were deeply unpopular. When the first decision came down in 1989, it came down right before, whenever the Supreme Court issues controversial decisions, they come down in sort of the end of June, because that's the end of their yearly term. The problem with the end of June, when you're issuing a decision saying that it's okay to burn the flag, is that it's right before the 4th of July. Not a good time to tell people it's okay to burn the flag. So Congress, in response to that decision in 1989, put off their 4th of July break for 2 days so that virtually every member of Congress could get up on the floor of Congress and say what an outrage this Supreme Court decision was. In order to amend the Constitution, you have to have, and I always get this wrong, but it's something like 3/4 of all the states have to approve the amendment, and 2/3 of the House and 2/3 of the Senate have to approve the amendment. So flag burning, when the Supreme Court said the Constitution, the First Amendment, prohibits the government from making it a crime to burn the American flag, people said, well, then let's change the Constitution. And they went around state by state with a resolution to amend the Constitution to excerpt flag burning from the protection of the First Amendment. And 49 states approved that resolution. The only state that didn't was Vermont, where Bernie Sanders comes from. But 49 states. The issue then went to the House of Representatives, where it passed overwhelmingly, 2/3. Hard to get 2/3 of the House, but it passed by well over 3/4 of the House. So it was supported by 49 states and supported by well over 3/4 of the House. And then that came up for a vote in the Senate, I think 3 times, and each time it failed by between 2 and 3 votes. Failed to get 2/3 of the Senate. So what that means is that 49 states, 3/4 of the House, and a strong majority of the Senate, right, virtually 2/3 of the Senate, approved amending the Constitution, and the Constitution was not amended. That's how hard it is to amend the Constitution. There have been 27 amendments to the Constitution. First 10 came in one, fell swoop with the Bill of Rights as a sort of condition to approving the Constitution. But in the 240 years since, 17 more amendments have been adopted. The last one to be approved was approved in the 1980s. It was first proposed well over 100 years earlier. It took about 100 years to be approved. And what does it do? It provides that when Congress increases the salary of its representatives, the ones who vote on the approval, the increase, can't get the increase. That's the next Congress that gets the increase. They can't self-deal. Not a terribly controversial proposition, right? And nonetheless, it took over 100 years to get it approved. So the amendment process is not an achievable way to change the Constitution. So how does the Constitution change? So I took up that question by looking at three areas where the Constitution has changed in our lifetimes in significant ways, and looked at three individuals, citizens who had a particular vision of the Constitution that was not reflected in the Constitution when they began, but was reflected in the Constitution by the time they finished. So the first is a guy named Evan Wolfson. Evan Wolfson in the 1980s was a law student at Harvard, and he was gay, and he decided that he wanted to write a senior thesis in his last year at law school on the right of same-sex couples to marry. And he went around to all the constitutional law professors at Harvard, and there are many, to ask if they would supervise his independent research on this subject. And they all turned him down because they said it was so off the wall, such a crazy idea, such a non-starter, that it wasn't worth their supervising him. He finally found a professor of trusts and estates, not exactly, the area of marriage equality, who agreed to supervise. He wrote a 141-page paper. He got a B+ on it, which I'm told is the lowest grade you can get at Harvard Law School. That was sort of, that could have been the end of it. Because at the time it was a non-starter. In 1972, a gay couple in Minnesota argued that they should have a right to marry on the same terms as opposite-sex couple. And their case went to the Minnesota Supreme Court, and the Minnesota Supreme Court thought so little of their argument that not one of the justices hearing the argument even asked a question of the lawyer who was representing the gay couple. And one of the justices turned his back on the lawyer for the entire argument. He was so offended by the notion that someone would make an argument that the Constitution protects this asserted right. They then wrote a decision saying, of course the Constitution doesn't protect the right of same-sex couples to marry. Citation, Genesis. Not your usual constitutional law citation, but that was their citation, the book of Genesis. They petitioned to the U.S. Supreme Court for review of that decision, 1972. The Supreme Court rejected that petition, saying it doesn't raise a serious federal question. So, it was a decade after that Evan Wolfson was writing his paper at Harvard Law School. It was still an off-the-wall argument. But as we know, in 2015, the Supreme Court recognized constitutional right of same-sex couples to marry on the same terms as opposite-sex couples. Second person I talk about is Marion Hammer. Marion Hammer is in her 70s. She's about 4'11". She never went to law school. And she is widely considered the most powerful lobbyist in the state of Florida. And she's a lobbyist for the National Rifle Association. She grew up on a farm, learned to shoot with her grandfather, shooting rabbits, was not particularly political. But in 1968, Congress passed the Gun Control Act, the first sort of significant federal regulation of guns in the modern era, and that politicized her. And she got involved with a local gun organization in Florida, the Unified Sportsmen of Florida, and eventually got involved also with the NRA, became the NRA's point person in Florida, which, as I'll talk about in a moment, is a central locus for NRA activity, and became the first female president of the NRA. When she became politicized about this notion of the right to bear arms, that notion was firmly rejected in the courts. The courts for over 100 years had said that the Second Amendment to the Constitution does not protect an individual right to bear arms. It protects the prerogative of states to have militias. The idea was state militias would be a check against federal usurpation of state authority. But it doesn't protect the rights of individuals to have guns in their homes, free of state regulation. That's what the courts had held for over 100 years at the time that Marion Hammer got involved with this issue. But her view was that the Second Amendment protected an individual right to bear arms, as Evan Wolfson's view was that the Due Process Clause and the Equal Protection Clause protected the right of gay couples to marry. In 1991, Chief Justice Warren Burger, just recently retired from the Supreme Court, gave an interview in which he said the notion that the Second Amendment protects an individual right to bear arms is one of the greatest frauds perpetrated on the American public in my lifetime. That was 1991. That was the Chief Justice of the U.S. Supreme Court, a Republican conservative Chief Justice. Fast forward to 2008, the Supreme Court, in a case called Heller versus the District of Columbia, rules that the Second Amendment protects an individual right to bear arms. The Constitution reflects Marion Hammer's vision, just as the Constitution reflected Evan Wolfson's vision. The last person that I talk about is someone very close to me, Michael Ratner. Michael Ratner was actually my mentor when I first became a lawyer after law school. He was a lawyer at the Center for Constitutional Rights. And in the wake of the terrorist attacks of 9/11, he became quite concerned. His offices, the Center for Constitutional Rights offices, are in Lower Manhattan. They were very close to the attack on the World Trade Center. People were obviously deeply affected by that. But Michael was concerned about some of the ways that George Bush was responding to the threat posed by that attack. And in particular, concerned about the fact that George Bush was bringing people to Guantanamo in secret, refusing to disclose even who they were, refusing to give them any sort of legal process, any kind of hearing, asserting simply that they are the worst of the worst, and asserting the power to detain them without charges indefinitely. And he believed that was wrong. Now, the Supreme Court had held in World War II that the courts are not a place that the enemy during a war can go to challenge the president. There was a case brought by German prisoners of war to challenge the legality of their detention in a prisoner of war camp. And it went to the Supreme Court, and the Supreme Court said, there's no access to court for enemy aliens during wartime. So George Bush felt pretty confident that he had the authority to do what he did at Guantanamo, to hold people in secret and refuse them any access to the courts. Michael Ratner filed the first case challenging the legality of the detentions at Guantanamo. He believed that in America, the government should not give the president unfettered discretion to lock up human beings indefinitely without any kind of hearing, without any kind of process. Constitutional law was against him. The Supreme Court decision was against him. I asked him in writing the book, I interviewed a lot of people. I interviewed Michael. I said, you know, what chances did you think you had of prevailing when you filed this case? He said, none whatsoever. It was completely hopeless. We filed 100% on principle. And yet, 4 years later, Supreme Court ruled, 3 years later, Supreme Court ruled that, for the first time ever, that in fact the president's authority to detain the enemy at Guantanamo was subject to judicial review through habeas corpus. And another 4 years later, in a similar case that Michael Ratner did with other lawyers, the court ruled that that is a constitutional right and cannot be taken away from the detainees, even if Congress and the president acting together say there is no judicial review. And by the time President Bush left office, over 500 of the people at Guantanamo had been released by President Bush. The CIA's secret prisons, where we were disappearing suspects to be interrogated using waterboarding and the like, had been emptied out by President Bush. The practice of torture, including waterboarding and stress positions and the like, had been ended by President Bush. The practice of extraordinary rendition, which was a practice in which we would abduct a terror suspect in country A and spirit him off to country B being a country like Saudi Arabia or Morocco or Syria, countries that we had routinely condemned for their use of torture in interrogating suspects, and we handed over the suspects to them so that they could torture them for us, asking them our questions. But that practice had been ended by the time President Bush left office. President Bush created a warrantless wiretapping program where the NSA was, as we now know, thanks to Snowden, monitoring our phone use and our internet use without a warrant, without judicial supervision. By the time he had left office, that program was under judicial supervision. So in each of these stories, individuals with a particular vision about what the Constitution should mean, facing existing law that was against them, nonetheless went forward and eventually were able to achieve substantial success. Eventually, the Supreme Court recognized marriage equality, the Supreme Court recognized individual right to bear arms, and the Supreme Court recognized that the president is in fact constrained by the rule of law in times of crisis. So the question I ask in the book is, how did that happen? How did marriage equality go from unthinkable, which is what it was in 1972, to inevitable, which is what it was in 2015? How did the individual right to bear arms go from being dismissed as a fraud by the Chief Justice of the Supreme Court to being recognized by the Supreme Court as a constitutional right in 2008, just 17 years later? And what caused President Bush and Dick Cheney to retreat on so many of their counterterrorism initiatives by the time they left office? And it wasn't a change of heart. If you read Dick Cheney and George Bush's memoirs, you will see that in their view, they never made a mistake. It was right to torture, it was right to disappear, it was right to send people to Syria so they could torture them for us, and they would do it again. So something caused them to retreat, and it wasn't that they changed their mind. So how did that happen? And the answer, I think, in all 3 cases is the work not of these individuals alone, but of these individuals in association with other like-minded citizens who came together in organizations that were committed to a particular vision and then engaged in a long-term, sustained strategy of advocacy, most of it outside of the federal courts altogether. Most of it outside of the federal courts altogether, that made it possible for this change in constitutional law not so much to be made by the Supreme Court as to be recognized by the Supreme Court. So if you think about the evolution of constitutional law as a sentence on any particular subject, whether it's marriage equality or gun rights or limits on the president in wartime, if you think about it as a sentence, the Supreme Court decision is the period at the end of the sentence. Maybe it's the exclamation point at the end of the sentence. But the work of that sentence is the work of civil society organizations, nonprofit associations of citizens who've come together in association to seek justice, to seek their vision of justice, and to engage strategically in a variety of tactics to change the conversation. So, take marriage equality. What changed between 1972, when the Supreme Court said, doesn't even raise a serious enough question for us to entertain the question, to 2015, when the court recognizes marriage equality as a constitutionally mandated principle? Well, the arguments didn't change. The arguments made in it's not like more clever lawyers came up with better arguments. The same arguments were made in 1972 as made in 2015. Due process and equal protection demand freedom to marry for same-sex couples on the same terms as opposite-sex couples. The court, well, did the court become more liberal? No, in fact, the court, if anything, the 2015 court was a more conservative court than the court in 1972. The court in 1972 was the tail end of the Warren Court, the most liberal court the Supreme Court has ever been. 2015 was the Roberts Court, a conservative court. So the legal arguments made by the lawyers didn't change. The judges, if they changed, they became more conservative. What changed was the world changed. And the Supreme Court recognized, didn't cause that change, the Supreme Court recognized that the world had changed. So how did that change come about? Well, Evan Wolfson graduated from law school. He went to work for Lambda Legal, which was at the time one of the few gay rights legal organizations in the country. He fought first within the gay community to fight for marriage, to convince people that it was worth fighting for. It was a controversial topic within the gay community in the 1980s. Many people thought, marriage, that's a patriarchal status quo institution. Why would we want to be part of that institution, right? But Evan took the view that no, marriage and the recognition of same-sex marriage is critical to the equal dignity of gays and lesbians, because it's really a statement about who they love, about their love. Is their love legitimate or illegitimate? And so he first fought within the community that this was an issue worth fighting for. Then once there was a critical mass believing that this was an issue worth fighting for, they thought, well, how do we fight for it? We know that if we file a case in federal court, we're going to get the same treatment that that Minnesota couple did. So we can't just file a case in the Supreme Court and append Evan Wolfson's 141-page paper to it. We would lose. So what did they do? Well, they looked for alternative fora. If the law is against you in the federal courts, well, maybe in the state courts you can establish this right. And the nice thing about the states in our system is that there are 50 of them, and they differ. And so if you have a particular vision, you might and that vision's not reflected in federal constitutional law, you might find a state that under its state constitution or its state law might be more sympathetic. And so they went to Vermont. Remember that state that wouldn't vote for a flag burning amendment. They went to Vermont and they thought, we have a pretty good shot of prevailing in the Vermont Supreme Court on a state constitutional argument. But they didn't immediately file a case even in the Vermont courts. Instead, they first created an organization to advocate for this issue. They went around the state educating people about gay and lesbian families. They sought modest, incremental amendments to family law, to Vermont family law, that would recognize, for example, the right of a lesbian mother to adopt the biological child of her partner. In other words, to recognize the legitimacy of that parental relation to the child of a gay couple. They got domestic partnership benefits adopted by, friendly corporations like Ben and Jerry's, and then by progressive cities like Burlington, and then by the state, that were extended to same-sex couples as well as opposite-sex couples. They got anti-discrimination laws to include discrimination against sexual orientation in a variety of places. And they went around to each of the senators in the Vermont State Senate and got a sufficient number of them to agree not to interfere with a judicial case, because if you bring a case in state court on constitutional grounds, one possible thing that happens is that the legislature changes the Constitution. But in order to change the Constitution, you have to get a certain number of senators. And so they went out to the senators and got a certain number of senators to agree not to interfere, let the courts decide. They did all that work, several years of work, before they filed the case. Then they filed the case, and they filed the case entirely on Vermont law grounds. They did not make a federal constitutional argument. Why? Because if you make a federal constitutional argument in state court, it can be reviewed ultimately in federal court, ultimately in the Supreme Court. And they didn't want to go to the Supreme Court because they knew what would happen if they went to the Supreme Court, they would lose. But if you make an argument based only on state law, on Vermont law, the Vermont Supreme Court is the end of the line, because the U.S. Supreme Court can't tell the Vermont Supreme Court what Vermont state law says. The Vermont Supreme Court is the final say on that. So they limited themselves to state law claims, and they won. And they didn't win marriage. They won something called civil unions, which was not marriage, but gave gay couples all the tangible benefits of marriage. So it was an incremental victory. They then took that victory and went to Massachusetts, another progressive state, where they did the similar kind of preparation, and then they filed a case there, and there, for the first time anywhere in the world, a Supreme Court ruled that state Supreme Court ruled that there is a right to marriage equality. That was the Goodridge case. They then had to fight, in both Vermont and Massachusetts, they had to fight a rearguard action as traditional marriage proponents sought to amend the Vermont Constitution and amend the Massachusetts Constitution to overturn those decisions. And they won those battles. They then took those victories, they went to Connecticut, got a decision there. They went to Iowa, got a decision there. They went to the New York State Legislature, and through the legislature they got an extension of the right to marry to same-sex couples. They went to the D.C. City Council, and they went to California, and they won in the California Supreme Court. They then had to fight another one of those rearguard actions, something called Proposition 8. It was an amendment, a ballot initiative to amend the Constitution, to overturn the Supreme Court decision of California and to define marriage as a traditional union between a man and a woman. And they fought that. They spent $40 million fighting that. The opposite side spent $40 million fighting it. And they lost that is, the marriage equality proponents lost. They lost in 2008, the year that President Obama was elected, in one of the most liberal states in the country. They lost. The decision of the people was marriage should be a union of a man and a woman, overturning the Supreme Court decision of California. So now what do? They, you know, in a year when you elect President Obama in one of the most liberal states in the country, you spend $40 million and you lose. So what did they do? Well, they didn't give up. They learned from their loss. They studied how they had argued for marriage in the public realm. And they concluded that this was that the way they were arguing it was not the best way to frame the issue if you wanted to reach the persuadable people who were uncomfortable about marriage equality, but open to argument. And you look at the marriage equality ads for Proposition 8, and what you see is the marriage equality folks saying, this is about civil rights. This is like the fight that Martin Luther King fought. This is like the fight that people fought against the internment of the Japanese. It's about civil rights. And they also had ads in which they'd have like a really hip, young, gay guy up there talking about marriage equality, and then they'd have some portly, middle-aged, very uncool guy up there expressing his concerns. And what they realized is, those ads are not going to appeal to the persuadables. Why? Because the first ads suggest that if you're against marriage equality, you're like a racist. You're like the people who favored segregation and the internment of the Japanese. And the second ad says, you're just uncool. Well, that's not how you reach people, right? So they crafted a whole different message in which they said, this is not about civil rights. It's not about equality. It's not about being cool. It's about love and commitment. It's about love and commitment, and it's about the right of two people to express love and commitment in a profound and hopefully permanent way. And that message, they got good messengers to express that message. So in Maine, for example, where this issue was again on the ballot, in a ballot initiative, all of the ads the people speaking in the ads are heterosexual, not homosexual. The older, the more Republican, the more religious, the more traditional, the better. So not your usual suspects, but actually the kind of people who you need to persuade. And so one ad, for example, shows a guy, he's in his 90s, he's sitting around a table with his entire extended family, 16 people or something. He was a fighter pilot during World War II. And he says, I was a fighter pilot during World War II. And I'm a Christian, and I'm a traditionalist. But I think people call me brave for what I did. I think real bravery is my granddaughter, Carol, who is in a relationship with Mary. And I believe that Carol and Mary should have the same right to express their love and commitment in the way that I and my wife did 45 years ago. And he's speaking from the heart, personally, about his transformation, essentially, to recognizing this right. And what happened when that was the frame? In Maine, in 2012, the people of Maine voted for marriage equality. The people of Maine, 3 years earlier, had voted for traditional marriage. But they turned it around and voted for marriage equality. And it was only after all that work had been done, in the states, establishing this right to marry in a variety of states, that the case ultimately went to the Supreme Court. And then the Supreme Court in 2015 recognized what what had happened, which is that the world had changed. It had changed through these arguments that had been taking place in the media, in schools, at work, in state legislatures, in city councils, in state Supreme Courts. And only once they had made progress did they go to the Supreme Court. Same thing with the NRA. The NRA, when it began fighting for the individual right to bear arms, which was in 1970s, the law was against it. If it filed a federal case, it would lose. So what did it do? It went to the states. It went not to Vermont, but to Florida, where Marion Hammer was its point person. And they passed laws at the state level to protect the right to bear arms. And they start in Florida, and then they take that law, and they go to Alabama, and then they take that law, and they go to Texas, and then they take that law. And by the time this issue went to the Supreme Court in 2008, and the question was, is there a federal individual right to bear arms? All of the states had recognized an individual right to bear arms through advocacy by the NRA. So they shifted the ground with respect to this right, a right which had been rejected. The states had now recognized it, and the question was, would the federal government recognize it? They also shifted the ground in the academy. In the 1970s, 60s, 70s, there were very few articles on the Second Amendment, but all the articles agreed the Second Amendment doesn't protect an individual right to bear arms. It protects the state's right to have a militia. So what did the NRA do? They supported scholars to do research to argue the opposite. And by the time this case went to the Supreme Court in 2008, the majority of scholarship in the law journals on the Second Amendment took the position that there was an individual right to bear arms protected by the Second Amendment, including articles by significant liberal constitutional law professors. They also got Congress to endorse, through legislation, an individual right to bear arms, understanding the Second Amendment, before the case went to the Supreme Court. Then they got the executive branch. When George Bush was elected, first time around, with significant help from the NRA, he appointed John Ashcroft as his Attorney General, an NRA member, and the NRA dashed off a letter to John Ashcroft saying, hey, what do you think about the Second Amendment? Does it protect an individual right to bear arms? Now, for about 100 years, the Justice Department had been saying it doesn't. But John Ashcroft says, I think it does. And he reversed the Justice Department's policy and ultimately generated a 100-page memo from the Office of Legal Counsel in the Justice Department saying there is an individual right to bear arms and laying out the argument for that. All that happened before the case went to the Supreme Court. And then in the Supreme Court, when the case went to the Supreme Court, the NRA filed an amicus brief, a friend of the court brief, on behalf of a majority of the members of the Senate in favor of the individual right to bear arms. A majority of the members of the Senate, a majority of the members of the House, and Dick Cheney. And the remarkable thing about Dick Cheney signing this brief is that the President and the Justice Department were actually on the other side of the case. They were defending the statute, the D.C. statute, as constitutional. And so George Bush is on this side of the case. Dick Cheney files on the opposite side of the case, arguing, well, I can do that because I'm not only vice president under President Bush, member of the executive branch, but I'm also president pro tem of the Senate. I have this position in the Senate, and so as a senator, I can express my view, which is contrary to the president. First time in history that a vice president has filed on the opposite side of the president in a constitutional dispute. And that was thanks to the NRA. And the Supreme Court recognized a right to bear arms. I don't have time to talk about the tactics that the human rights groups used to push back against President Bush's measures in the war on terror, but I'll just say briefly that it's a little bit of a different story because you can't go to the states. You can't go to the states on a matter of national security. That's federal business. And so, whatever Massachusetts thinks about national security, doesn't really matter. So, but like the gay rights groups and like the gun rights groups, you had to find alternative fora. And one of the most sympathetic alternative fora that the human rights groups found were foreign populations and foreign governments, which then brought pressure to bear because it was their people who were locked up at Guantanamo. You know, it wasn't our people, it was their people, and they put pressure on Bush. You know, if you don't release our people, we're not going to cooperate with you in the war on terror, et cetera, and over 500 people got released. It's more complicated than that, but there's a critical similarity in the finding of alternative fora in which you can make arguments that are not recognized in the Supreme Court so that they can eventually be successful in the Supreme Court. So, what do I conclude from all of this? Well, first of all, that the Constitution and constitutional law is more democratic than we sometimes think. We often talk about the Constitution as being a constraint on democracy, and it is. It is. But in fact, when you look at how constitutional law changes, how it changes over time, it changes through the engagement by citizens in politics and debate over an extended period of time to change minds about fundamental values. And then the Supreme Court doesn't so much change constitutional law as recognize that it has changed as a result of this democratic process. And I think that's a good thing because, there's a fundamental question in constitutional law. Why should we be bound by Constitution? If we decide as a majority today that it's a good idea to do something, let's say pass Obamacare, right? And the Supreme Court comes along and says, actually, it's unconstitutional, which they almost did, right? It was one more vote, and the Supreme Court would have said it's unconstitutional. Then the question is, if the majority of the American people think that the best thing to do is to provide health insurance to poor people, why should we be barred from doing that because 5 justices said we can't? So there's 2 arguments, for why we should be bound by the Constitution. One, well, it's a contract. We agreed to it, and it binds us. The problem with that argument is we didn't agree to it, right? Who agreed to it? A lot of dead people. And who were those dead people? They were white men with property. They didn't even reflect the majority at the time that they reached the agreement, because women didn't have the right to vote, people without property didn't have the right to vote, and of course, African Americans didn't have the right to vote. They weren't even treated as full people. So, that's not to me, that's not a very satisfactory answer. The fact that these dead people, 240 years ago, agreed to a set of things and made it really hard for us to get out of the agreement, that's not very persuasive to me as to why we ought to be bound by the Constitution today. But if instead we are bound by the Constitution because it reflects our deepest commitments, our values today, then that makes some sense. And it makes sense that sometimes we will have deep commitments that we will be tempted in the moment to violate. And it's important to have a document, a set of principles that holds us to our deepest commitments, even when we go astray. But it only reflects our commitments if it evolves over time. And it only reflects our commitments if it evolves over time through a kind of democratic engagement, deliberation by the people. If it changes over time because 5 justices happen to change it over time, well, that's also not a very good argument, because why should we be bound by what 5 justices think? They're not responsive to the people. But if it changes over time because of the work that organizations like, the NRA or the Lambda Legal or the ACLU do, through this kind of democratic deliberation, well, then it is reflective of our values, our commitments, and it makes sense, makes more sense anyway, to be bound by it. So that's the first point. Second point is that when we think about the enforcement of constitutional law, we tend to think about the separation of powers and judicial review. That's how we enforce constitutional law. The power of the court to declare something unconstitutional. But what this argument suggests is actually, it's more complicated than that, and a central role in the enforcement of constitutional law and the evolution of constitutional law is civil society. These organizations, us, citizen activists who come together. Even after the Supreme Court recognized the right to bear arms in the gun case, the NRA is a more powerful protector of the individual right to bear arms than the Supreme Court is. They can block laws that the Supreme Court would clearly uphold under the Second Amendment, and they can get laws passed that the Second Amendment certainly does not require. Third, these evolutions don't all go in one direction. The examples of the NRA and the gay rights groups illustrate that. But the point is not that we're moving in some, progressive direction towards truth, but that we control what our Constitution means and says, and we do it through engagement. This is where the action is. And so if you care about some fundamental issue, some constitutional right, the thing to do is to get involved with like-minded citizens who similarly care, to engage in the kind of extended fight for your rights that is critical. I close the book with a quote from Learned Hand, who was, many people say, the greatest judge never to sit on the Supreme Court in America. Certainly had the best name of any of the judges not to sit on the Supreme Court in America, Learned Hand. And he said the following. He said, "Liberty lies in the hearts of men and women. When it dies there, no court, no constitution, no law can save it. While it lies there, it needs no constitution, no law, no court to save it." And like many great quotes, this is an overstatement, right? We need courts, we need the Constitution, we need law. But he's absolutely right that liberty lies in the hearts of men and women. And the role that I think civil society, citizens coming together around their commitments to liberty, play is in ensuring that liberty indeed lies in our hearts so that it does not die. Thank you very much. Yeah, happy to take any questions if you have.
Have a couple minutes for questions. Well, I think, let me just start with something that I've been thinking about, and it's, the story of the NRA and its success. The other side of that story, moms demand action for gun sense in America.
Yeah.
Do you have any comment on the likelihood that the opposite view, or that even in the face of an individual right to bear arms, that group of civically engaged people could create a climate in which change could be made to allow for different.
So absolutely. So great question. I mean, and one of the messages of the book is, constitutional law is not. It's not stationary. It changes over time, and it changes in response to engaged citizenry. The NRA understood that. They understood the democratic underpinnings of constitutional law, and they used the political process to press their position very, very effectively. And whether you agree with them or disagree with them on the merits, they are certain. I think everyone. It's hard not to admire their tenaciousness, their strategy, their use of the democratic process to this end. Well, so what about the other side, right? They weren't the only, and there's always another side, right? There's always groups on both sides. Well, the problem is that the other side was focused in Washington, was not a big we're not big membership organizations, but we're sort of elite organizations focused in Washington, focused on Congress. The action the NRA understood was in the states. The NRA has affiliates in all 50 states. It has 5 million members. It has 15 million people who say they're members but don't pay their dues. And the NRA would like to have their dues, but they really like the fact that they say they're members. And why? Because when they urge them to vote for this candidate over that candidate because this candidate has a views more protective of gun rights, they will do that. That's the power of democracy. The gun control groups were organized at the elite level, didn't have a grassroots base, were not active in the states at all. And so when NRA was going around and getting all these laws enacted, there was virtually no opposition in most of the states. That's changing. Mayor Bloomberg, his Every Town for Gun Safety organization is trying to learn from the NRA, learn from their message, engage, create a grassroots organization at the local level throughout the country. There's significantly more money being put into the gun control side of things. And so over time, it is quite possible that there will be pushback. But it will turn on that kind of engagement. You know, when Roe versus Wade was decided, the right to life folks didn't take it as well. The Supreme Court has said there's a right to abortion for women. That's the end of the matter. No, they organized, they strategized, they got laws enacted in sympathetic states, and they cut back on, in a fairly significant way, the right to terminate a pregnancy. They have not succeeded in their eyes, but they have undermined the right of Roe, and they would have undermined the right of Roe much more dramatically had there not been active engagement by Planned Parenthood and the ACLU Reproductive Freedom Project and the Center for Reproductive Rights fighting just as hard on the other side. So, you know, the answer is it will depend on the engagement of citizens, but that's where constitutional change happens.
So ironically, federal change happens because you're active at the state level.
Yeah, well, it's like both the gay rights groups and the NRA used a federalist strategy to achieve a federalist, that is state-based strategy to achieve national change. And the same thing is true if you go back to the suffragette movement, the right to vote for women. The suffragette movement got something like 17 states to recognize the right of women to vote before they got a federal amendment. Yeah.
So basically what you're saying is that because the Supreme Court is at like such a high level, that if there's no like precedent, you're out of luck. So what they went to like the most basic, like smallest level and started building up support for precedent, and then precedent like leading up to like the highest level. So it's something that, like, if it's a major issue, will take like a solid like 10 or 20 years.
Oh, absolutely. This is not a fast, right? People say, oh, marriage equality, that happened in a flash. But in fact, it was a 30-year intentional campaign by a significant number of organizations and activists across the country. The gun rights campaign the NRA began in earnest in 1977, and it wasn't until 2008 that they succeeded, and they're still fighting, right? So these things, the Constitution is designed to resist, swift changes. It's designed to constrain the momentary democracy. But yeah, it's precedent in a kind of broader sense. It's not federal court precedent that these groups were establishing. It was really they were establishing the validity of their normative argument in a variety of different forums other than the federal courts, so that when they finally went into federal court, that argument would not be seen as crazy, which is what it was seen when Evan Wolfson wrote his paper, but as actually one that needs to be taken seriously, which is what happened in 2015. Yeah.
Was there a similar organizing effort prior to Roe versus Wade?
Yeah, so Roe versus Wade, there was some similar efforts to legalize abortion, and they'd made some progress, but it wasn't as sustained and well thought out. And the Roe case itself was brought by two, individual college women or graduate student women. It wasn't brought by a kind of organization. And one of the criticisms of Roe that Ruth Ginsburg makes, for example, is that the court sort of decided the issue before there had been this kind of groundwork. What I'm talking about is the groundwork that you need to do before you can get the constitutional right. In that instance, they got the constitutional right before the groundwork, but some argue that that's what caused the other side to be able to successfully push back, because it wasn't sufficiently well established. But there is some historical work that demonstrates that there was, in fact, a development of the right to abortion outside of in some states, outside the federal courts, that made it, conceivable to make that argument. Okay.
Well, again,
Oh,
thank
no,
you very
there
much.
was someone else? I don't see. Okay. Yeah, I'm sorry, I can't.
I wanted to ask you about the death penalty.
Yeah.
Attitudes are changing. I know it's inevitable. One day they'll look at the Constitution and feel I need to punish us with the death penalty. I'm wondering if you have some comment on that.
Yeah, similar story. In fact, when I was originally thinking about writing this book, I thought I might do the death penalty story, and I might do the fight against Roe versus Wade also, because they're both instances in which people with a profound commitment, in both instances often religiously based commitment, fight against the existing state of the law to try to change it, and have made some significant progress. Neither one of those groups has prevailed, but I think the death penalty folks will prevail. Just a study this week, the Pew Charitable Trust found that for the first time there is less than majority support, less than 50% support in the public for the death penalty. I think now 25 states, something like 25 states, have gotten rid of the death penalty. Another several do not enforce it, even though it's on their books. The number of death penalties handed down by juries has dropped to below 80. The number of per year, there's 20,000 homicides a year. Less than 80 death sentences handed out. In terms of actual executions, they're now down to, I think last year there were 29 executions. So all of the trend lines are going towards making it more and more rare. And eventually, when it is, and the vast majority of death penalties are handed down by a handful of jurisdictions in a handful of states. So it really is becoming an outlier through this kind of political advocacy at the state level. And when it's a sufficient outlier, I think the court will take up the invitation that Justice Breyer made just 2 years ago to renew the argument that it is now cruel and unusual. If it gets to such a small number, then it gets very hard to argue that this is a rational system for taking the 20,000 homicides that occur throughout the country every year and picking the 29 worst cases and executing only those people. That is not what happens. What happens is the 29 people who were unlucky enough to have been in districts where you had prosecutors who pushed for the death penalty, juries that were very favorable toward the death penalty, lawyers who were asleep or drunk or did not present a very effective. It's not the worst of the worst. It's the ones who happen to get the worst lawyers who get the death penalty, and that's arbitrary and irrational. So I think in our lifetime we will see that happen. I don't think it's going to happen next year, but I do think it's coming, and it's coming through that same kind of incremental evolutionary process that is pushed by advocates who are very committed to the principle of life and to the principle that we should not be taking other people's lives. All right. Well, thank you.
Excellent.
you.
And I remind you that we have